This was the first time a matter of this nature came before the National Assembly. Parliament adopted the rules around the removal of a Chapter 9 institution head just 2 years ago.
Therefore, it was by order of the court that rules were established, which we followed as members of Parliament to make sure that any motion that came before the House would be just and would be done in the correct fashion. We have now had a panel of who I think, and I'm sure many would agree, are three of the finest legal brains in our country, agree that there is prima facie evidence which require this panel to sit.
This, without a doubt, is unconstitutional persecution of a black woman whose only sin was to demand accountability from the poster boy of white monopoly capital. Parliament is to embark on shameful illegal process to remove a head of an institution supporting democracy and will not allow this to happen.
The IFP supports the recommendation that this inquiry now move on to the next stage, namely the establishment of a parliamentary committee, which will further interrogate the findings and that will present its own findings and recommendations to the House.
We need now to appoint a committee in terms of the rules of the National Assembly to take this process further, and the Freedom Front Plus will definitely support that, and we ask all members to do the same. Thank you.
So when we vote today on whether or not to refer the matter to the committee, we should set aside our political views and vote in the same manner that judges do when they make decisions, when they consider on this basis of prima facie evidence. Impartiality, independence and objectivity should be brought to bear with a view to acting rationally when we so vote.
The UDM objects to the recommendations of the independent panel. We acknowledge the importance of Section 194 of the Constitution. However, in this case of the incumbent public protector, Advocate Mkhwebane, regulations or rules were specifically drafted for her with retrospective effect.
ATM demands that the Honourable Speaker withdraws and suspends any discussions on the independent panel report until the courts have pronounced themselves on the legitimacy of the process.
The National Freedom Party will support a committee to be put in place, but however our concerns are the independence and objectivity of members on that committee so that the public protector is given an opportunity to present her side of the case.
I urge all South Africans through this Parliament, of course, to check what the public protector must do if she finds wrongdoings as directed by the constitutional obligations in Chapter 9.
The inquiry must not proceed. Constitutional democracy will be harmed if access to justice outside our courts is not available, that is free and quick and without the time-consuming and high costs.
As the ANC, we are mindful of the fact that we are dealing with a matter of public interest. And as public reps, we must at all times be seen to be processing matters of public interest. With this understanding, Honourable Speaker, the ANC supports the motion to establish that Section 194 multi-party committee which will deal with this matter and also which will afford the public protector an opportunity to make a representation, because it is not fair that the public protector is seen is walking around with this dark cloud hanging on her head.
Over the past few days, some ANC MPs have come out in support of Mkhwebane, saying they would never support a DA-sponsored motion against her. Following the voting process, National Assembly Speaker Thandi Modise again asked if there were any MPs wanting to vote against their parties. However, the House fell silent and no one came forward to take up on that offer. Abra Barbia, SABC News, Parliament.